A written prohibition on the use of consumer AI tools is a sticky note on an unlocked door. It does not prevent entry. Contracts, technical controls, training, and enforcement must reinforce the policy, or it remains paper. In United States versus Heppner, a financial services CEO charged with securities fraud used the free consumer version of Anthropic's Claude to analyze his legal exposure. He acted on his own, without his lawyer's direction. Some of his prompts included information he had received from counsel. When prosecutors sought the AI-generated documents, the court ordered them produced, rejecting both privilege and work product protection. Claude is not an attorney. Anthropic's consumer terms disclaimed confidentiality, and the materials were not prepared at counsel's direction. But the court left room for a different outcome. Had counsel directed the defendant to use Claude through a platform with proper confidentiality terms, the result might have been different. That distinction, consumer versus enterprise AI, frames the advice that follows. Consumer AI platforms may, under their default terms, retain user inputs, train on them, and disclose data to third parties. The consumer terms that helped defeat privilege in Heppner can also compromise trade secrets, breach NDA obligations, or expose regulated personal data. For lawyers, the concern runs deeper. Entering confidential client information into a consumer AI tool may violate ABA Model Rule 1.6c, which requires reasonable efforts to prevent unauthorized disclosure of information relating to the representation. If your clients use AI for anything involving confidential or sensitive information, a policy marks only the starting point. Here is what to tell them. First, client employees may be entering deal terms, personal information, litigation strategy, financial projections, or regulatory materials, each carrying different legal obligations. Help clients classify what their people are putting into AI tools. Second, offer to review the AI platform's terms with the client. Look specifically at provisions on data retention, training on inputs, human review, and third-party disclosure. The terms should bar training on customer data, restrict provider access, and impose confidentiality commitments. Watch for carve-outs that could weaken a confidentiality argument, including provisions for anonymized data, safety review, or service improvement. Third, advise clients that consumer tier plans may lack critical protections. Consumer terms often permit data retention and provider access that enterprise agreements prohibit. Enterprise plans typically add audit logs, custom data retention controls, and negotiated commercial terms. Fourth, recommend that clients work with IT to block consumer AI domains on company networks and manage devices, and to add data loss prevention tools that scan for sensitive data sent to AI platforms. No single control is airtight. Employees on personal devices or off-network connections can bypass corporate gateways, but layered defenses reduce exposure. Fifth, remember that convenience is gravity. If the enterprise tool requires 3 logins and a VPN, employees will likely turn instead to the consumer alternative. Sixth, be sure to train the people who handle confidential information. Every employee who handles confidential information should understand the line between enterprise and consumer AI and know that what they type into an AI tool may later be produced in discovery. Seventh, at the outset of any legal, regulatory, or compliance matter, ask whether anyone used AI tools to analyze or discuss the issue. Prior consumer AI use may have compromised privilege before the matter reached you. Make this question as routine as the litigation hold notice. And eighth, update litigation hold and preservation protocols. AI interactions are ESI subject to preservation obligations and discovery requests. Chat logs, uploaded documents, exported files, and AI-generated summaries should all be covered by litigation hold notices and retention policies. Remember, AI use raises challenges well beyond data protection, from hallucinations to the risks of agentic tools. The steps above focus on one aspect of AI risk: keeping confidential and sensitive information out of the wrong platforms. AI use can fall outside the legal protections many users assume exist. Companies that close that gap will be prepared when confidential information is challenged, records are demanded, or regulators come calling, those that wait may confront the consequences in discovery, in a disciplinary proceeding, or both.